We will go ahead and officially get started. We are here for oral argument in CR 20-0352, State versus Wise. As you know, and we have had occasion to say a couple of times recently, each side has a maximum of 20 minutes for argument, and you are not required to use it all, though you're welcome to do so. For the appellant, you may reserve some portion of your time for rebuttal, and you are responsible for managing that time as you are responsible for managing the time that you are sharing with amicus. To make that more difficult, because we are handling this argument remotely, I will be keeping time manually. If you'd like, I'm happy to give you alerts periodically. You may also keep time on a cell phone or whatever timer that you have handy with you. But you can ask for an update on your remaining time at any time. We are recording this argument. We will ultimately post our recording to the court's YouTube channel. So for clarity of record, please do identify yourself and your client when you begin speaking. Now, we of course hope that no connection failures occur, but should one of the judges lose connection, that judge will review the recording later. If one of the attorneys presenting loses the connection, we will suspend the argument until we can regain that connection. Please do keep in mind, as is usual, we've read all of your briefing, we've studied the record, we've discussed the case in conference this morning. And with that, you may proceed.
Thank you, Your Honor. May it please the court, my name is Michael Minikazi. I represent the state in this appeal. And the state is asking that this court distinguish the facts of this case from the facts of Crosby-Garbatz v. Fell, decided by the Arizona Supreme Court in 2019. In doing so, we ask the court to consider two overriding principles here. First, that issue preclusion is heavily disfavored in criminal cases and should be applied sparingly. I would use the analogy of a directive to a court informing the court that it should construe a statute in a strict manner, meaning that it should limit the application of that statute, not expand upon it. And the same is true with this directive. It's also worth noting.
Cancel, but the problem I see is while I may agree with our directive, the Arizona Supreme Court has determined in cases very similar to this that issue preclusion does apply, and I'm not sure how we get around that.
And Your Honor, in response to that, what I would say is this. There is a distinction here that is a substantial distinction that warrants a different conclusion in this case. The fact that it is a severance hearing in a hearing that is closed to the public as a matter of law denies the public access to view the proceedings. And actually
but counsel, in Justice Timmer's dissent, he made a large point out of dependency proceedings may be close. You use that in very much the same way that you're using it here, and the majority of us not persuaded.
And Your Honor, Justice Timmer does mention it in her dissent. However, two things to that. First, there is a difference between might be closed to the public and shall be closed to the public that I think warrants a distinction. And two, the majority never really acknowledges Justice Timmer's dissent in that regard. They do address certain features in the majority in Crosby, but if you read the majority in Crosby, there's never a point where the court really addresses the public interest. They just give a very flippant statement and move on. So it's never really addressed. So, and because issue preclusion is to be applied sparingly, I would suggest to the court that we shouldn't read into much what is not written by the majority. And because the majority does not write on this particular issue, it should be given that kind of weight.
Well, the fact that the majority did not write to that issue does not necessarily equate to a statement that they did not consider it. As Judge Howell points out, Justice Timmer raised it, so naturally they considered it. That they chose to not write to that is a separate issue.
But it is the fact that they did not write about it that I think leaves this court with less guidance on how it should respond to what is a different scenario. Because in this case, in a severance, there is no public access versus a dependency where it is presumed to be open to the public, but can be closed to the public. So I think that is a distinction that matters. And part of that is because of how important the public participation is in a case. One last point I would make about issue preclusion being disfavored, Crosby does acknowledge in the majority opinion that it is the exceptional case where a ban on relitigation should be. So that combined with the rule that it is disfavored is an important distinction here. Second, the public interest in the accuracy of the fact-finding process is at its peak in a criminal case. It is more important than the fact-finding process in a civil case or in a juvenile case. That's kind of where I start with the problems with applying issue preclusion.
Well, Counsel, we may agree with you on that, but that seems to be an issue that was discussed and in both opinions, and the majority didn't see that as a concern. So again, I'm not trying to give you a hard time. I understand the situation, but I don't know how we can distinguish the case on a basis that was discussed in the Crosby opinion.
Counsel, you have 14 and a half minutes.
Thank you, Judge. And Your Honor, what I would say is, I think that distinction, though, between may be closed and shall be closed makes the difference here. Because the court did not write about this, I think we must exercise caution in expanding something that is naturally supposed to be limited in its application. I would say this, if this were the equivalent of where it was to liberally be construed in the defendant's favor, then yes, I could see us expanding beyond what is written in Crosby. But because it's the opposite of that, I would encourage the court to not read beyond the words that are written into the opinion. The public, and the distinction here that the state is basing this on is the public access, because there are two primary guarantees of accuracy and fact-finding in a criminal case: the right to public trial and the right to a jury trial. The U.S. Supreme Court has said that public scrutiny enhances the quality and safeguards the integrity of the fact-finding process. Open trials discourage perjury, prevent misconduct on the part of the participants, and ensure that decisions are not based on a secret bias or partiality. In a separate case, the Supreme Court has said that it improves the quality of testimony, induces unknown witnesses to come forward, and causes all trial participants to perform their duties more conscientiously. These words matter. These aren't words to be given lip service to. There is a substantive difference between the juvenile proceeding that is closed to the public and a jury trial, or even a non-jury trial that is open to the public in criminal court. The Supreme Court has said these guarantees make the fact-finding process more accurate. And one thing that has been noted in Mr. Wise's briefs is that the state disputes the finding of the juvenile court. The state does not come here to dispute the finding of the juvenile court. The juvenile court's findings are sufficient for juvenile court. Because the fact-finding process it needs to be more accurate in a criminal case, the state says that that's not sufficient for a criminal case, what was done in juvenile court.
Counsel, so
go ahead.
thank you. if on your point that public scrutiny improves the process, if the Supreme Court, when it took up the First Amendment issue, the dissent took up the First Amendment issue, if the Supreme Court was concerned about this difference, don't you think the opinion in Crosby would have said that this case is that ruling was specific to matters where the proceedings were closed, that perhaps the outcome would be different otherwise, or something of the sort, rather than not making a statement on that at all?
And Your Honor, what I would say is this: it is hard to know what the Supreme Court would do with a different set of facts, but the Supreme Court majority opinion does address some of Justice Timmer's dissent. They do actually address some of her arguments. But by not addressing certain other ones, I think it leaves questionable for us what guidance has been given in these scenarios that aren't specifically addressed by the majority. And this was one that was not specifically addressed by the majority. So another thing about the importance of the public trials is that public trials, if they are not granted in a criminal case, result in an automatic reversal because they are structural error, which is an error that infects the entire trial process and creates a situation where the results are not necessarily reliable. Now, bringing all this together, I would cite to the restatement of judgments 27 and 28, which the Supreme Court has said that we follow in Arizona and did follow in the Hewlett v. Cousin case, and is mentioned in Crosby as something that the Supreme Court does follow. And 28.5 states that if there is a situation where there's a potential adverse impact on the public interest or on the interest of a third party, that issue preclusion should not be applied. And I would suggest to this court that both of those scenarios are present here. The public interest is adversely affected by applying issue preclusion here, and so is any potential victim who would be a third party.
Counsel, something that I'm interested in the majority opinion in Crosby, it says that the parties are the same, that the Department of Child Safety and the state or the county are the same because they're using the power of the government, and they refer to the fact that the AG does the criminal appeals for the county, and that's what makes it one party, the same party. Can you address that?
You have 8.5 minutes.
Thank you, Judge. Yes, Your Honor. It's hard to argue. I think there is this legal fiction that I mentioned in my opening brief that we are all the same party. There is no doubt in my mind that because we speak with different voices and have different elected officials, often from different parties, that it is somewhat unfair to attribute what is said by one agency to another agency, especially when they're represented by a different elected official and have different purposes. But I also recognize that the law has said that we're all the same party. But the public has its own interest that's not even necessarily incorporated into the state, because that's what Rule 28.5 says, that the public interest is adversely affected. But we also do not represent the victim in a case. The victim is a third party. And actually, this is a good time. I will turn it over to Mr. Lorden from Arizona Voice for Crime Victims, and he'll speak for a few minutes, and then he'll reserve some time for rebuttal for me.
Thank you. You are on mute, sir.
I wanted to thank the state for sharing time with us, and I want to leave the state with at least 4 minutes for their rebuttal. I don't know how much time that gives me.
You have
but
7 minutes right now.
All right. If Your Honor, if I run into that, if you'd tell me to be quiet, I'd appreciate it. Thank you. I only want to make a few points in outline form and of course take any questions. Since I'm with Arizona Voice for Crime Victims, I'm here to advance the interests of crime victims in cases like this in Crosby. The rights of crime victims in Arizona law are critically important, indeed of constitutional dimension. And the Supreme Court's decision in Crosby and the trial court ruling in, that's the subject of this appeal, never considered crime victims' rights in applying collateral estoppel from the juvenile to the criminal context. Most crime victims' rights, by their own terms, apply only in criminal cases. They don't apply in juvenile cases. And the result of the application of collateral estoppel in cases like these is to deny crime victims the opportunity to exercise their rights as crime victims. No criminal trial, in effect, means virtually no crime victims' rights.
You have 6 minutes.
The application of issue preclusion in these cases cuts off victims' rights after they've vested and denies victims the standing they would otherwise have to assert those rights. I agree with Mr. Minikazi's citation to Section 28 of the Restatement Second of Judgments. Certainly under 28.5a, where it talks about the adverse impact on third parties, one of the principal third parties would be a victim. Further, given the statutory definition of victim at ARS 13440119, there are in fact multiple victims in cases like this in Crosby. For example, in this case, crime victims would include BW's grandparents, his sister, any other person related to him by a certain degree, and any other lawful representative of BW.
5 minutes remaining.
If
Counsel,
BW were
counsel,
alive, sorry.
Even if we agree with your position that crime victims' rights are cut off because the matter is decided outside of the criminal case, is it your position that we would be able to ignore the Crosby decision?
Well, I'm not sure you can ignore the Crosby decision. Having said that, I think the Crosby decision was wrong.
Or overturn it, as has been suggested?
Well, the Crosby decision should be overturned somewhere.
But are you suggesting it should be overturned by us?
Sure. Well,
do we have power to do that?
You're at 4 minutes.
Yeah, I don't know if you have the power to overturn it or not. I recognize the distinctions made by the state as between this case and Crosby-Garbatz. So there is a basis to distinguish the cases. Beyond that, whether you have the power to overturn it or not is a separate question that I don't address. I do address the validity of Crosby-Garbatz insofar as it's involved in this case, and would urge that Crosby-Garbatz was wrongly decided for the reasons set forth, not just in our brief and in the state's briefs in this case, but for the reasons set forth by the dissent in Crosby-Garbatz.
Thank you.
The appellee began by saying there is no victim in this case and then said, well, the mother is a victim. But as I'm pointing out, there are a number of victims, possible victims.
You have 3 minutes left.
In this case, if BW was alive, he would be a victim, and crime victims as such do not have any standing to assert any rights in juvenile cases. Virtually any rights crime victims may have in a juvenile case will be rights they have not because they're crime victims, but because they can somehow claim some other rights, not crime victims' rights, in the juvenile case. And here, the appellee in their responsive brief said, well, look, any third party can become a party or a participant in a juvenile case under rules 37A and B. I disagree with that assertion. Under rule 37A, the definition of those who are parties by definition does it necessarily overlap with those who are victims for purposes of criminal law? Moreover, even though someone can intervene.
Appellant has 2 minutes left.
I'm sorry, that's 2 minutes in the appellant side of the case. Let me stop there and keep that time for Mr. Minikazi's rebuttal. And I'm sorry I went this far. Thank you.
Yes. Mr. Head?
May it please the court, my name is Kevin Head, and I represent Mr. Wise, the appellee in this matter. This court should affirm the lower court's ruling dismissing this case because, as the state has conceded below, and again on appeal, the 5 elements of issue preclusion have been met. Despite this concession, the state asked this court to grant its request to burden and harass Mr. Wise with successive litigation concerning the same factual allegations with the same insufficient evidence, which after 22 days of a public trial, the juvenile court not only found to be insufficient, but that Mr. Wise had proven his innocence and that the state's theory of guilt was physically impossible. The state did not.
Can you talk about the unity of the parties here? It does seem concerning to me to say that the county attorney and the Department of Child Safety are one party.
Sure, Judge Howe. First, the element of mutuality is not before this court. It wasn't disputed below, and it's been conceded in the trial court and on appeal. So to that extent, to the extent this court's still concerned with it, an issue not presented to the court, it should be alleviated by the analysis by our Supreme Court in Crosby, which held that the state is one entity and that the state pursuing charges in a criminal case is the same entity in a juvenile court case. And if you look at the record of the case, mutuality isn't a concern because we have the same evidence being presented. Now, is it an extraordinary coincidence that the state's theory and evidence is the same in juvenile proceedings as it would be in criminal court? We see the notice of witnesses, the experts, the witnesses are the same. So for those reasons, mutuality is not an issue that should concern this court because it's been conceded.
Well, the fact that I would expect the evidence to be similar, if not the same, or else we wouldn't really be discussing issue preclusion at all. But when you have a separately elected government official prosecuting the case, then you have a separate elected official doing the juvenile proceeding, I'm finding it difficult to say that's all one party. I understand that that's what Crosby says, but it still concerns me.
Judge, that Crosby says it should be highly persuasive to this court, if not binding. The fact that the state has not contested mutuality in the trial court on appeal should alleviate the court's concerns. And the fact that there's nothing in the record to establish that the state in the termination proceedings did anything against the interest of the state in the criminal proceedings. And when we look at juvenile proceedings, any interested party or agency can intervene. The state, if there was a dispute between prosecution and dependency, could file something, establish what that dispute is, and explain why there is an actual factual mutuality, despite the law saying that there is. So there's nothing in this record to establish any sort of support for your concern that maybe in another case, mutuality shouldn't be addressed. And that gets me back to the 3 main reasons why this court should affirm the lower court's ruling and reject the state's request to force Mr. Wise to run the gauntlet a second time. 1, it's compelled by precedent. 2, the juvenile proceedings were public and no victim's rights were denied in this case. And 3, even if this court were not bound by precedent and the record fairly presented the issue that the state claims it does, the state has not met its burden of proving a clear and convincing need for a retrial because the public has no right to compel a second trial as it only has a right of access, which is qualified, not absolute, and does not extend to the point where it may force a trial to be conducted at all, let alone after a full and fair adversarial proceeding has been held and there's been no challenge to the reliability of the judgment of that proceeding. So starting with the first issue, I think the judges on this panel have acknowledged that in paragraph 33 of the dissent in Crosby-Garbots, Justice Timmer raises the issue that the state presents on appeal, and the majority rejected it. We know the majority rejected it because the dissent's analysis is in the dissent. But if you take a step back and you look at what Crosby-Garbots holds, what it holds is that we've had the same elements of issue preclusion in this state dating back to 1932. And even though there's an allegation that there's some public interest concerning this exception to issue preclusion found in the Restatement 28, Section 5, or subsection 5, that there's no need to reanalyze or change the way that Arizona courts address the issue of issue preclusion, even if it's coming from a juvenile court to criminal court. And the reason why the majority held that is because when fairly applied, each of the 5 elements of issue preclusion, it addresses the public policy concerns of the state. And so before Crosby and after Crosby, we have the same law. Where the 5 elements are met, issue preclusion applies, even in criminal cases, even after a finding or a judgment coming from a juvenile court. The state has conceded. Yes.
Issue preclusion. So let's, for just this question, set aside Crosby-Garbots and the nature of that as precedent. Issue preclusion is in a doctrine of judicial efficiency. So although the elements might be met, are we required to apply it in every case where the elements are met, or is that a matter for the discretion of the court, depending on whether or not it's seeking to uphold that judicial efficiency argument?
Setting Crosby aside, you still have every other case in Arizona looking where the elements are met, it applies. And so any case in the Arizona history where issue preclusion was not applied based on the request of a party, it's because one of the elements weren't met. And you see that in paragraph 21 where the court talks about the importance of the full and fair opportunity to litigate. And the full and fair opportunity to litigate encompasses the possibility that there may be a disparate public interest in the 2 proceedings, such as one party may not have an incentive or the ability to litigate the issue fully. And so there's not a single case that's been cited in Arizona where the elements have been met that the doctrine of issue preclusion doesn't apply. And so when you look at the record in this case, I'm going back just to Crosby in a minute because I don't think we can just dismiss Crosby as easily as the state suggests. They assert that the Arizona Supreme Court was flippant in issuing its ruling. When you read the ruling, it fully addresses all of the concerns raised by the state and why the existing elements of issue preclusion are sufficient. In paragraph 16 of Crosby, we see the court comparing other jurisdictions which have declined to apply the doctrine of issue preclusion in similar circumstances. One of those cases, State v. Cleveland out of Washington, you see the state of Washington has a different test for issue preclusion. There's a different component in its elements. On element number 4 is the issue of whether or not application of the doctrine must not work an injustice. So we see in Washington, it is a different test than the traditional elements in Arizona. And the Arizona Supreme Court rejected the idea that it should modify its test because the existing test works. There's no need to really consider the exception as a categorical bar. And so in paragraphs 20 through 22 of the opinion, it talks about how the issue preclusion addresses these public policy concerns. Now, the state gets it wrong when it says that issue preclusion in criminal cases will always be exceedingly rare. It's true that issue preclusion in criminal cases, the court said, would be rare, but the state's provided nothing to establish that isn't the case. I've looked at since Crosby was decided, how many times has this issue come before this court, Division II, or back to the Supreme Court? And so there's nothing to suggest that post-Crosby application of the doctrine isn't rare. What should be rare, and the Supreme Court noted this in paragraph 20, is that relief from preclusion where the elements are met should be rare. And when you look at the comments, the state bears a heavy burden of establishing a clear and convincing need for a retrial. And this gets back to the question, I forget which judge asked it, as the purposes of issue preclusion. Judicial economy is one of 2 purposes, right? The second purpose, which is paramount to this case, is the effect on the litigants, the harassing, burdensome nature on the litigants. If Mr. Wise wasn't already indigent in 2013, he surely would be now after fighting this case for 7 to 8 years in court and then being the subject of facing it again in criminal court. There's a financial burden that is often recognized in the civil context on the litigants as to why issue preclusion applies. But there's also an emotional and public perception burden that is facing criminal defendants. Now, much of the state's argument relies on one crucial fact, which the state hasn't established, is that it alleges that these proceedings in juvenile court were not open to the public. And I apologize, I started my timer late. Can you give me an update, Judge Perkins?
10 minutes and 15 seconds.
Thank you. So this, if you look at the beginning of the proceedings on June 4th, 2019, the judge there says, I don't need to know who's back there after the parties announce their presence. Okay, so if a judge is holding a private proceeding where the public's not allowed to attend, why would the judge have a complete indifference as to who's in the courtroom if the proceedings aren't public? But so the record actually establishes, and it's not my duty as the appellee to establish facts to prevail, it's the appellant's duty. And in fact, the state, talking about being flippant, has been flippant with a long-standing process of appellants, both in criminal and civil, for the duty to perfect the record below, to avoid waiving issues, and to present citations to the record sufficient to establish facts necessary to prevail on their legal argument. Instead, the state says...
Counsel, I understand the argument that there may have been someone in the courtroom, so that makes it open. Does this issue hinge in your mind on whether it's open or closed?
At the end of the day, it doesn't change because the state bears a burden of proving a clear and convincing need. And where there's no challenge to the reliability of the initial determination, where the evidence is the same and they can't meet the lower burden of clear and convincing evidence. But as is here, not only did the state fail to meet its burden, we have rulings establishing that the juvenile court found Mr. Wise did not abuse BW, that he's innocent, and that the state's theory of guilt is physically impossible. The state never challenged these findings, never challenged the reliability of these findings, yet it insists that it can carry its burden of showing a clear and convincing need to bring this case to trial a second time. But there's a second issue with that.
But counsel, I understand the bounds of Crosby, but a question that I have is: we have made a decision that criminal matters need to be tried in a public manner in the public, and have a jury of the defendant's peers, the public, decide the issue. If we allow issue preclusion in a non-criminal proceeding, which may or may not be open, and the public may or may not be involved, if we apply issue preclusion, then that means that a critical fact that would otherwise be presented in public, decided by the public, is not. How do you reconcile that?
It's quite simple to recognize, Judge Howe. Not one single case stands for the bold proposition that the public may compel a criminal case to trial at all. If that were the case, there would be no plea bargaining, there would be no elective dismissals by the state, and Rule 20 would be unconstitutional. And so in the United States Supreme Court recognized this fundamental premise in Gannett Company, Inc. v. de Pascal, a case that the state relies upon. It said, the court noted in 1979, it could be hardly seriously argued that a member of the public could demand a jury trial because of the societal interest in that mode of fact-finding. Not one case stands for the proposition that the public has a right to a particular disposition of a criminal case. And in fact, as it relates to victims, the Supreme Court, a year after deciding Crosby-Garbots, noted that victims have no constitutional right to a particular disposition of a criminal case. And when you look at the purposes...
As long as we are venturing into the issue of jury, the right to trial by jury, isn't it true that while the public cannot compel a trial to be brought forward, the state does have the right to have criminal cases heard and decided by a jury, even when the defendant chooses to forego his or her right to a jury trial, it still can't be done without the consent of the state. Isn't that true?
That's true, and the majority recognize the ability of the state to deal with this in Crosby, right? And so the state is not precluded from pursuing parallel proceedings, and it can make a decision to pursue the criminal case first. In fact, the criminal case was on track to go first. The state filed 2 special actions to ensure that this juvenile proceeding occurred before the criminal proceeding. By the time of the second special action, this case was set for trial in criminal court, but the state pushed this to trial in juvenile court. And so to say that the state has a right to a jury trial while forcing these proceedings to trial in a non-jury manner doesn't fairly reflect the record. And the state notes this argument that it's structural error concerning the non-jury nature of a criminal trial. Structural error is relating to the deprivation of a constitutional right for a criminal defendant. The right that you're referring to, Judge Cruz, is a statutory right. It's not a constitutional right on part of the state to a jury trial, and they're in the driver's seat. They get to choose which proceeding to push to trial first, the jury trial in criminal case or the non-jury trial in the juvenile case. But going back to one of the threshold questions, which this court hasn't asked many questions about, is does the law really require a termination proceeding, which involves the fatality of a child, to be private? Now, again, I don't think this court should gloss over what the state's asking it to do, to infer from a silent record that these proceedings were private, because again, that turns the burden on its head as the way that appellate cases work, with the appellant bearing the burden of proof of the facts and to make the record. But also it switches the presumption, and the presumption of all judicial proceedings is that they're public, and that in order to become private, there needs to be findings made on the record. We see that in criminal cases, as recognized in State v. Young with the adoption of the Waller test, that the court needs to make findings. And we see that in 8525B, which Justice Timmer, I think, cited in her dissent, where the statute. I'm sorry, Judge Perkins.
Sorry, 3.5 minutes.
Oh, thank you. And we see that in 8525B, which outlines procedures. Now, aside from flipping the presumption of a public nature and flipping the presumption of that a silent record supports the lower court's ruling and that this court will uphold it where there's silence on the record, let's look at the statutory construction argument that the state presents in its reply brief, which is also backwards. It argues that 537 is a specific statute, a broad statute concerning how termination proceedings are conducted, and that 525, a specific statute, is a general statute when it's titled the purpose of the statute addresses whether or not the proceedings are public. And so, in order,
I apologize. In the short time you have left, you were talking about the order of the proceedings. When you have the county attorney in charge of the criminal prosecution, and you have the Department of Child Services running the dependency proceeding, how can you say that they're acting together when you have 2 different agencies making independent decisions?
There's not a record that these decisions were independent, Judge Howell. And we have the record before this court is that the concession that there's mutuality. And if there was an issue between conflicting decision-making where DCS was indeed forcing this case to trial over the MCAO interest, we would see a record of that in this case and not a concession on mutuality. And we don't have that. And so back to the statutory construction argument, 525 is specific. This court would have to ignore the plain language, and to the extent it finds a difference or a conflict between the statutes, ignore a canon of construction which requires this court to harmonize those statutes and harmonize 525C, which is a more specific statute requiring these proceedings to be public. And so it requires a bunch of backwards analysis in order to even reach the inference the state wants this court to reach, that these proceedings were not public. But as to the restatement, the state bears a heavy burden, and that relief from preclusion is a rare exception, as Crosby noted. And also in the comments in subsection G, it says that litigation to establish a particular exception should not be encouraged, and that they need to make a compelling case. We don't have that record here because we don't have any challenge to the
1 minute.
reliability of the findings. Thank you. We don't have any challenge. We don't have any proof that the proceedings were not public. As to victims' rights, the victims' rights group ignores the interest of the only victim in this case and the record in this case, which A, establishes that no rights were violated and that there was nothing to suggest that the victim did not have notice of these proceedings in the parallel case. And so it persists in asserting that there was a victim in this case, but when there's no offense committed, there's no victim. And there's not one case that says where there's an acquittal or a determination that there's not an offense committed, that a victim status persists. And that's if you look at the definition in the constitutional provision, there's no victim unless there's an offense that's been committed. And victims' rights in the criminal case, the right to notice, and we know what the victim wanted in this case. She supported Mr. Wise. She asked at the beginning of the case that his conditions be released. And we know in the juvenile proceeding, the judge made a finding that she was resolute in her belief that Mr. Wise was innocent of these charges. And that's exactly what the juvenile court found. The state hasn't challenged the reliability of that finding, and instead is insisting that some victim right to healing, as the amicus present, to a second trial, a show trial.
Your time has run.
Thank you.
Thank you. I assume we're back to Mr. Minicozzi, and you have 2 minutes remaining for your time.
Thank you, Judge. 2 points I want to make in the 2 minutes I have. First, this court does not have the power to overrule Crosby, but it has the power to distinguish it. And the power to distinguish is a very significant power of this court, and I would encourage the court to use that power. The second issue I want to address is this. The idea that the state had the ability to pick which proceeding went first is completely false. The state had a legal, ethical, and moral obligation to get that juvenile severance hearing done as quickly as possible, given the requirements of the law, which say that juvenile severances must be done in an expedient manner, because there is another person, another interest waiting in the balance while we litigate this issue. In this case, Mr. Wise's surviving child, who was taken from his custody when she was a newborn, and it took 5 years to get that hearing to go. To suggest that the state is responsible for picking and choosing which one goes first, the state had a legal requirement to get that hearing done as quickly as possible. The state had to come to this court 2 times to get the trial court to make that hearing happen. And all while this young child, when bonding and emotional bonds are at the most critical stage, that's just not happening. Criminal cases naturally take longer to get resolved than juvenile hearings. So if we were to
30
wait,
seconds.
we would be creating horrible public policy. So I would request that this court reject that argument outright. I would also mention this, that there are other victims in this case. Mr. Head wants to keep referring to one victim, but the law recognizes multiple victims. I would ask this court to overturn the trial court's decision in this case and allow this case to proceed to trial. Thank you.
Thank you. Thank you to all the counsel for your arguments. We will take the matter under advisement and issue our decision in due course. Court is adjourned.
Thank you, judges.
Thank you, Your
Thank
Honors.
you, counsel.